Arbitration, you can present evidence, or you can have arbitration and just present it orally. You can present testimony if you want to in an arbitration. Some arbitrations last weeks. Some of them last a couple of hours. It depends on the rules that you decide to apply to the arbitration. Another thing that's similar to that, you can have binding or non-binding arbitration. Binding means both sides agree that they will be bound by the result as if they would if a jury decided the case. And generally, you have no right of appeal. So if you agree to a binding arbitration, then you're bound by whatever that result is. There's really no provision for an appeal in our rules. If you agree to a binding arbitration, that is usually going to be the end of your case. Whereas in a trial with a jury, you go through the whole procedure. There's an appeal much of the time. Either side can appeal to the Court of Appeals. And in Florida, we have two Court of Appeals, two levels. So we have the district court, which has to hear every case. They decide up or down whether or not the rules were followed by the trial judge. And if you lose, you can try to get your case to the state Supreme Court. The Supreme Court has limited jurisdiction. It only handles cases where the districts have a dispute on the same fact pattern, or if a district judge certifies a case of great public interest. So it's very limited what cases can go to the Supreme Court. Most states that have a Court of Appeals and a Supreme Court are set up the same way that Florida does. So that's a big difference between arbitration and a trial, is really the right of appeal.